Welcome to Vango Notes for Human Resource Management, 11th edition, by Gary Dessler. Chapter 2, Equal Opportunity and the Law. Section 1, Big Ideas. Did you know that a jury in New York recently ordered Walmart to pay Patrick Brady $7.5 million for violating the Americans with Disabilities Act? Walmart hired Brady, who has cerebral palsy, to work as a pharmacist's assistant. But after just one day, the store reassigned him to collect carts and pick up trash. In another case, Boeing recently agreed to pay up to $72.5 million to settle a suit by female employees who claimed they were paid less than men. And Morgan Stanley settled a similar suit for $54 million several months later. In fact, hardly a day goes by without reports of equal opportunity-related lawsuits at work. Yet, legislation barring discrimination is nothing new. For example, the Fifth Amendment to the U.S. Constitution states that no person shall be deprived of life, liberty, or property without due process of law, and the 13th Amendment outlawed slavery and is used to prohibit racial discrimination. But these two amendments were passed during the 19th century. What kinds of legislation have been passed since then? Let's look at some of the equal employment opportunity laws that were passed from 1964 to 1991. Civil unrest among minorities and women during the early 1960s prompted Congress and presidents to take dramatic action concerning equal opportunity employment. Title VII of the Civil Rights Act was one of the first results. Title VII, amended by the 1972 Equal Employment Opportunity Act, states that an employer cannot discriminate based on race, color, religion, sex, or national origin. It bans discrimination on the part of most employers, including all public and private employers of 15 or more persons. In addition, it covers all private and public education institutions, the federal government, and state and local governments. This law also established the Equal Employment Opportunity Commission, or EEOC, to administer and enforce the civil rights law in employment settings. The Commission's 5 members are appointed by the President with the advice and consent of the Senate, and there are also thousands of staff members in offices around the country. In addition to Title VII, various U.S. presidents have issued executive orders expanding equal employment in federal agencies. The Johnson administration issued Executive Orders 11-246 and 11-375. These orders don't just ban discrimination, they also require contractors to take affirmative action to ensure equal employment opportunity for those who have suffered discrimination in the past. These orders also established the Office of Federal Contract Compliance Programs to implement the orders and ensure compliance. For example, it reached a settlement with an aviation contractor to pay over $240,000 to settle claims that female and African American employees were subjected to a perversely hostile work environment. In 1963, Congress passed the Equal Pay Act. This law makes it unlawful to discriminate in pay on the basis of sex when jobs require equivalent skills, effort, and responsibility to perform equal work under similar working conditions. In other words, men and women who perform substantially the same job in terms of skill level, education needed, and work environment must be paid comparable salaries. Another group, workers over the age of 40, gained extra employment protection with the passage of the Age Discrimination in Employment Act of 1967. For instance, in the court case O'Connor versus Consolidated Coin Caterers Corporation, the Supreme Court held that an employee who is over 40 may sue for discrimination if he is replaced by a significantly younger employee, even if the replacement employee is also over 40. In addition, in 2004, the U.S. Supreme Court found that this law does not protect workers under 40 from being treated worse than older workers. This act is a favorite among lawyers, since it allows jury trials and double damages where willful or intentional discrimination is proven. In 1978, Congress passed the Pregnancy Discrimination Act as an amendment to Title VII. This act prohibits using pregnancy, childbirth, or related medical conditions to discriminate in hiring, promotion, suspension, or any terms or condition of employment. Also, if an employer offers its employees disability coverage, then it must treat pregnancy and childbirth like any other disability and include it in the health plan as a covered condition. In other words, if an employee misses work for a knee surgery and that surgery is covered as a temporary disability, then any female in the company who becomes pregnant must also have her pregnancy covered as a temporary disability, including insurance coverage and time off. From the late 1970s to the early 1990s, no notable discrimination legislation was passed. However, several Supreme Court rulings in the 1980s had the effect of limiting the protection of women and minority groups under equal employment laws. This soon prompted Congress to pass a new Civil Rights Act. So, in 1991, George H.W. Bush signed the Civil Rights Act of 1991. The effect of this legislation was to roll back equal employment law to where it stood before the 1980s decisions, and in some respects to place even more responsibility on employers. A final piece of equal employment legislation we'll look at is the Americans with Disabilities Act, or ADA, passed in 1990. It bars employers with 15 or more workers from discriminating against qualified individuals with disabilities with regard to applications, hiring, discharge, compensation, advancement, training, or other terms and conditions of employment. It also says employers must make reasonable accommodations for physical or mental limitations unless doing so imposes an undue hardship on the business. Examples of reasonable accommodations include access ramps, special computer setups, and office furniture. The ADA does not list specific disabilities. Instead, EEOC guidelines say someone is disabled when she has a physical or mental impairment that substantially limits one or more major life activities. By now, I hope you can see that equal employment opportunity legislation is aimed at ensuring